2020 NDC presidential candidate John Mahama has accused the Electoral Commission of vote padding, engaging in wrong aggregation of valid votes and breaching constitutional provisions. These actions, he argues, resulted in the unlawful declaration of the NPP's Nana Akufo-Addo as president-elect. He wants the Apex Court to set aside the declaration by the EC and order a second election between himself and Nana Akufo-Addo. Court correspondent Joseph Akable was at the Supreme Court as representatives of John Mahama filed the election petition on his behalf.
For hours, anxious pressmen waited to see if John Mahama will meet the 21-day deadline allowed for the challenge of a presidential election results at the Supreme Court. Few minutes past midday, member of the NDC legal team Edji Tamaklo, accompanied by NDC National Communication Officer Sami Jemfi, walked into the Apex Court registry to file the petition.
His lawyers have filed a petition challenging the constitutionality of the 2020 presidential results declaration.
The former president wants the Apex Court to set aside the results as declared by the EC. He alleges analysis of some 32 constituencies shows vote padding in favor of Nana Akufo-Addo. He therefore concludes that the results as declared by the Electoral Commission breaches Ghana's constitution since no candidate obtained more than 50% of the votes cast. He wants the court to set aside the declaration and order a runoff between himself and MPP's Nana Akufo-Addo.
Well, here are the reliefs being sought by former President John Mahama. And there are a number of them, and we'll be sharing them with you. There are about 6 reliefs in all, and it indicates a declaration that Mrs. Jean Adukwe-Mensah, chairperson of the first respondent and the returning officer for the presidential election held on December 7, 2020, was in breach of Article 63, subsection 3 of the 1992 Constitution in the declaration she made on December 9, 2020, in respect of the presidential election that was held on December 7, 2020. Now, the second, a declaration that, based on the data contained in the declaration made by Mrs. Jean Adukwe-Mensah, chairperson of first respondent, and the returning officer for the presidential elections held on December 7, 2020, no candidate satisfied the requirement of Article 63.3 of the 1992 Constitution to be declared president-elect. Now, we move on to C, where it says a declaration that the purported declaration made on December 9 of the results of the presidential election by Mrs. Jean Adukwe-Mensah, chairperson of first respondent, and the returning officer for the presidential elections held on December 7, 2020 is unconstitutional, null and void, and of no effect whatsoever. And then D, an order annulling the declaration of President-elect Instrument 2020, CI 135, dated December 9, 2020, issued under the hand of Mrs. Jean Adukwe-Mensah, chairperson of first respondent, and the returning officer for the presidential elections held December 7, 2020, and gazetted on December 10, 2020. And then E, an order of injunction restraining the second respondent from holding himself out as president-elect. Now, the final one is F, an order of mandatory injunction directing the first respondent to proceed to court to conduct a second election with petitioner and first respondent as a candidate as required under Article 63(4) and 5 of the 1992 Constitution. Now, joining us via Zoom now is legal practitioner Samson Ladi Ayenini on what to expect. Thank you very much, Samson. Now, what do you make of the petition as filed by lawyers of the NDC presidential candidate?
Yeah, Israel, we are not allowed by law to debate the substance of the petition, but what I can say is that the sum of the petition effectively is that by the numbers that they have put together, they make the conclusion that the requirement of Article 63, Clause 3, that if you go into a presidential election the winner must have won. You can only be declared a president-elect if you had more than 50% of the total valid votes cast. The sum total of the petition is that, by their calculation, the two candidates who had the highest votes, i.e. John Mahama, President Akufo-Addo, both or each did not make the more than 50% valid votes required to cross the threshold to be declared president-elect. Therefore, they are asking, as you see in the reliefs, that the declaration by the EC chairperson on the 9th of December, which is in CI or instrument number 135, be declared or be nullified. If it is nullified, what it means then is that we do not have a president-elect. So they then proceed to ask, ultimately, that in the circumstances, there should be a runoff as required by the Constitution, that if more than one candidate goes into the elections and each does not obtain the mandatory requirement of more than 50% of valid vote cast, there must be a rerun. So that's what they are asking for.
All right. Now, something I'm looking at, since you brought it up, I'm looking at release D and F and wondering whether it may have any effect on the swearing in of President Akufo-Addo for a second term. And in fact, do these two reliefs being sought by former President John Mahama amount to an injunction?
Right. So the first one you refer to requests the court to injunct Akufo-Addo from holding himself out as the president-elect. And the second one requires a mandatory order to the Electoral Commission chairperson to rerun or to run a second election. Am I correct?
Yes.
Great. Now, these are reliefs they have asked. Unfortunately, they are reliefs that will be determined at the end of the suit. They will not be determined before the suit ends. In the normal scheme of things, we will normally put the injunctive relief in there, and then we will file an application subsequently asking the court to grant an injunction to stop the person from conducting themselves in a certain way. But this is a constitutional situation where there must not be a vacuum at any time in the country. Therefore, there will be a precedent. But ultimately, if they win, the Supreme Court has the powers to declare that the president-elect was not validly elected.
All right. Now, from what you've just said, I'm getting the impression that if former President John Mahama actually wanted an injunction or wanted to stop the swearing in of President Akufo-Addo, he should have filed a separate application.
He could have filed that along with this one, but he would have filed this one before he files it. The timelines, if you look at the top right corner of the process, you will see that the time of filing is indicated there. So he could have filed it, if he filed this one at 2 p.m., he could have filed that application also at 2:05 or 2:03 p.m. He could also have filed that any time after he has filed this, meaning any time from today. But he has not given any indication in the suit that he intends to do so.
All right. Now, let's stay with, let's go back to the relief F that former President John Mahama is requesting. It says an order of mandatory injunction directing the first respondent, which in this case we understand to be the EC, to proceed to conduct a second election with petitioner and first respondent, again, which you've already known to be the EC, as the candidates as required under Article 63, 4, and 5 of the 1992 Constitution. I don't know what to call this. I'm not sure I can call it an error, but clearly there's some confusion there. How does this present before the Supreme Court?
So when you look at the face of the documents, you will clearly identify the first respondent to be the Electoral Commission or its chairperson, who is the returning officer for the presidential election.
Even though with that, again, somewhere along the line, you have the two being interchanged.
Right. So what really matters is what you find at the start, which is written in bold.
All right.
Identifying the parties. Now, this is a clear, avoidable error that has been committed. And I would say the Supreme Court or the court does not indulge in trifles. Whilst we say that, it is also, significant to note that this is embarrassing, to say the least, particularly for a petitioner whose officers have told the whole world over a long period that they were going through a painstaking process to ensure that what they will file, they have dotted their I's and crossed their T's. It is embarrassing to see that this error could appear. There is actually, as I checked, more than one of these errors, but they are typo errors where in the standard practice, when we go to court, a judge could even draw your attention and then ask you to use pen, ink, to make the correction and initial against it or sign against it. So to that extent, it is inconsequential. It is not fatal. It's avoidable. It's embarrassing.
All right. All right. Thank you very much, Samson Ladi Ayenini, legal practitioner and journalist of the year.